Okay. Good morning, everyone. I'm Laura Shaughnessy. I serve as Chair of the Professional Counselor Advisory Committee of the Kansas Behavioral Sciences Regulatory Board. I ask that the members of the advisory committee respond to a roll call to signify their presence at the open meeting that's being conducted remotely by conference call and other electronic means. Jim Kilmartin.
Present.
Good morning.
Good
Harriet
morning.
Bachner. Harriet Bachner.
And I don't see her on the call.
Oh, okay. Melissa Briggs.
Present.
Good morning.
Good morning.
Michael Countryman.
Present.
Good morning.
Good morning.
Michelle Fairbank.
Hello. Present.
Good morning. Acha Goris.
Present.
There you are. Good morning. Bob Kircher.
Present.
Good morning.
Morning.
Vanessa Perez.
Present. Morning.
Good morning. Andrew Secor.
I did get a note from Andrew and also Adil. They're going to be about 10 to 15 minutes late this morning. So,
Okay, terrific. So we'll acknowledge them when they jump on. Okay. Is Leslie Allen here?
she's actually on vacation this week. So,
I hope you'd say that.
I'm
Oh.
getting back to the BSRB soon. And then
You know-
Leslie next week. So,
Great. Good. We'll tell her we're glad we're not going to see her for a few weeks. I note the following BSRB staff members are present, and that would be David Fye. Good morning.
morning.
Next, David Fye will read a message concerning this meeting being held remotely.
This is David Fye, Executive Director for the Behavioral Sciences Regulatory Board. Public comment allows the public to address the advisory committee about its concerns, but the Kansas Open Meeting Act, or KOMA, does not require the advisory committee to provide public comment or answer questions from individuals. Individuals requesting to provide public comment could contact the executive director prior to the meeting by sending an email to david.fye@ks.gov. There will be no public comment at this meeting to allow sufficient time for the committee to go through the items on the agenda. Because we're conducting this public meeting remotely by conference call and other teleconference ability, I state for the record the following information. Public access to this meeting is being conducted by medium of interactive communication that allows members of the public without cost to attend the meeting through the use of the conference call and on the board's YouTube channel. While the meeting is conducted remotely, the requirements of the KOMA are not suspended, so we will be conducting this meeting pursuant to KOMA. On March 29th, 2023, we sent notice of the advisory committee meeting to all individuals who had requested notice of advisory committee meetings. The notice was also posted on the board's website, ksbsrb.ks.gov. You may obtain a copy of the notice at that website. An agenda and other meeting material have been posted on the board's website and are available for review. You may also request a copy of the agenda specifically by sending an email to david.fye@ks.gov with the subject line request for the agenda, and it will be sent to you. The notice contains information for the conference call and the YouTube channel that allows the public to attend the meeting free of charge. The notice also states that if there are any technical issues during the meeting, you may call the board office at 785-296-3240 or send an email to bsrb@ks.gov. A recording of the meeting will be available on the BSRB YouTube channel following the conclusion of the meeting by using the link to the meeting on the agenda. And the conference call line is active. I checked it before the meeting began and there was no one on the conference call line, but I'll let you know if someone beeps in.
Great. Thank you, David. The meeting is now called to order and the advisory committee will begin discussion of the first item on its agenda, which is agenda approval. So you've all hopefully had a chance to look at the agenda. Does anybody have any questions or additions? And if not, we just need a motion and a second to approve the agenda.
So moved.
And I see a couple of seconds. I'll do Acha seconding. All those in favor say aye.
Aye.
Any opposed? Okay, we will adopt the agenda. Next, review and approval of the last meeting, the minutes from the last meeting. That was on February 6th. Hopefully you've all had a chance to take a look at them. Does anybody have any changes or questions on those? And I see that Andrew Secor is now here. For the record, he's here. Good morning, Andrew.
Morning, Laura.
So again, any questions or comments on the meeting notes from February 6th? Need a motion to approve those minutes and a second?
Motion to approve.
Thank you. And thank you, Vanessa and Michelle. All in favor of approving those minutes, say aye.
Aye.
Aye. Any opposed? Okay, the minutes, they're approved. And now let's go on to our executive director's report. David Fye.
Thank you, Laura. I'll give you a couple of updates in terms of BSRB activities, but I'll probably spend the majority of my time talking about legislative updates because it's been a very busy legislative session, especially in terms of mental health legislation. So first, just one item in terms of BSRB operations. Last year, there was some federal dollars that were available due to the pandemic, and they opened some funding availability for agencies to apply for. One of the categories that you could apply for was modernization of technology or equipment. And so we went ahead and submitted 2 requests for funding to buy a camera, which would allow us to do hybrid in the board office more effectively. And then also to replace an existing projector in the board's office too. Part of that is to work with the camera in terms of being able to have both an effective meeting for those that were in person and also those that are remote. As we kind of find out a new way of doing things after the pandemic has moved to a better place. And so we were approved for both of those funding items, and we received a little over $2,000. And so we have been in the process of making sure that we're filling out all the appropriate reports regarding those federal dollars, and those items should be purchased here very shortly. So I think those will be available for any board meetings, and then also any advisory committees that would like to have hybrid meetings. That should be a nice benefit to the office, and we saved a little bit of money for licensees with that funding as well. In terms of some, I did want to mention too, Adil has entered the meeting as well, so he is now present. And so
Morning.
I'll go ahead. Okay.
Thank you.
In terms of some legislative updates, I wanted to make you aware. So there is a bill that we talked about last year and this year. It involves the Professional Counseling Multi-State Compact. It was House Bill 2288. And as you might recall, that bill is a sort of a uniform bill between different states that would need to be passed for those states to become part of the members of that Professional Counseling Compact. And the first states that started passing that model legislation was a couple of years ago. I think Maryland and Georgia were the first 2 back in 2021. And then last year, a number of other states passed legislation to join that compact. And enough states joined last year for the Compact Commission to start meeting. And then in the fall, there was an official request from the advisory committee to consider supporting that compact. And really want to thank the Kansas Counseling Association and also all the individuals that were involved in that process. You know, we had individuals from ACA and others from the Council of State Governments as well come and present information at the advisory committee, give us a chance to ask questions and learn more about that compact. And as you may recall, the advisory committee recommended to the full board support of the compact. And also representative from the Kansas Counseling Association approached the board and provided public comment at a board meeting requesting the board support that legislation if it came before the legislature this year. And so the board was supportive of that. And when that bill went in front of the House and the Senate committees this year, I presented testimony, proponent testimony in favor of the bill on behalf of the board. And as you might recall, that professional counseling compact would involve the clinical level of licensees for the professional counseling compact and would allow individuals who are member states to be able to get a privilege to practice or apply for a privilege to practice through the Compact Commission when all the infrastructure has been up and running. And so that bill did pass the House and then it passed the Senate. And when it passed the Senate, it passed without change, which meant that once the Senate had passed that, it could go to the governor. And just last week, the governor reviewed it and went ahead and signed it into law. So that bill has now gone through the appropriate steps. The implementation date is July 1st. So very excited about that. The next step from a practical standpoint is that the Compact Commission, even though it was able to start meeting last fall, there's still a number of steps that need to be taken in terms of building that infrastructure before we would be able to start issuing those privileges to practice. But it's a really big step, and Kansas will officially be joining that compact this year. So I just want to thank everyone that was involved in that process. I really do feel like this was a very transparent process that allowed the board and the advisory committee to be able to ask questions and learn about it, that it really was a collaboration. We were able to walk through it together and really appreciate that. And so I'll provide more information as we get more information from the Compact Commission. But I just wanted to say a big thanks and make sure that you all were aware of the passage of that bill. And I'll go ahead and pause before I go on to other legislative items to see if anyone has any comments or questions about the professional counseling multi-state compact.
I would just like to mirror what David said and thank you for all of the participation, all of the groups and organizations that helped to make this compact possible. We didn't really have any pushback because there was so much transparency, so much good information shared. It was a much easier process than I thought it would be. And so I just want to say thank you. This is going to be a great thing for our state.
I just want to say, I think it was neat that it was the 300th bipartisan bill that the governor had signed, so it got spotlighted. She signed several bills that same day, but those bills just got mentioned as like, here's other bills that she signed, but ours had a nice entire press release surrounding it, so it spotlighted the compact and our profession, and also demonstrated the ability of the Congress and of course the governor and such to work together as well. So I thought that was nice to see that as well.
Great, thank you.
When that bill was going through the House, there was one small amendment that was made to the bill. So in terms of the actual language of the compact model legislation, you can't change the terms within that model legislation, but there has been a ruling for some of the other compacts that in order for states to absorb any cost of being a member in the compact, they're able to charge a small fee if they go ahead and pass something that allows them to do that. In terms of anyone who has a home state license who is participating in the compact. So there was some language added by the House that would allow the board to do that. Just from the board's perspective, I think one of the things is right now there's language in the model bill which authorizes the commission to charge member states a fee to be part of that compact, but that really hasn't been resolved yet. And so if there is no charge to the state of Kansas to be part of that compact, I'm not certain that the board would need to implement any kind of a fee for that. If there is a charge to the state to be part of that compact, it might be a way the board could consider recouping some of that cost. But right now, without knowing if there would be a cost, I think that issue is just going to be probably set aside until the other issues resolving the compact are figured out by the compact commission. So with the bill talked about, I wanted to move to some other items involving legislative updates. One item is that so every year, all state agencies, their budget is approved by the legislature. And so as a fee-funded board, we do not receive any money directly from the legislature. We operate based on the funding that we receive through issuing licenses. And then we collect those dollars and they stay in a fee fund. And then we expend dollars from that fund for operations. And so the role the legislature plays for us is they set a limit. And so every year that appropriations bill establishes a limit and we can't spend above that amount, even if we had extra dollars in the fee fund. And so this year, the governor recommended the amount that we were approved for by last year's legislature for the current year. And then we submitted a budget request for the next 2 years. And those budget request dollars were recommended by the governor, the same as what we had requested. And additionally, when it worked through both the House and the Senate side, both the House and the Senate recommended the same amounts that we had put forward, as well as the amounts that the governor had recommended. So from a dollar standpoint, we had increased the budget based on potential increases in things that were charged to us for things like the licensing database that hosts our information, legal services, and other costs. There was one item that I wanted to highlight for you that was a bit unique. So when the budget went through the process, the House Higher Education Budget Committee was the committee that heard the agency's budget. And when it went through that budget committee, the budget committee added a proviso onto the budget. And what a proviso is it's extra language that either requires an agency to do something or prohibits them from doing something. And so in this case, the language that was added would prohibit the BSRB from adopting or imposing as a requirement for obtaining or renewing licenses or permits, any incentives or requirements that applicants for licensure or permit undergo, demonstrate familiarity with, or support any training, education, or instruction program that includes diversity, equity, inclusion, anti-racism, critical race theory, or other related topics. And it was noted that the language does not apply to equal opportunity or equal employment opportunity materials designed to inform individuals about the prohibition on discrimination based on protected class under state and federal law. And so this may seem strange, and it is unusual. Most budget committees do not add proviso language onto a budget, but there were questions during the budget hearing about the BSRB bill that was put forward this year on behalf of the board's recommendations. And within that bill, one of the board's recommendations was to require a certain amount of continuing education and cultural diversity training. And so one thing the budget committee did was to add this proviso language, which would essentially prohibit the agency from requiring as a condition or renewing of licensure requirements in those categories that I listed there. And so the BSRB does not currently require that. And as I'll talk about in a little bit, when I talk about the bill, that part was amended out of the bill. But from a practical standpoint, at least for the next 2 fiscal years, I believe that any type of continuing education or other training that the BSRB may want to require in this area, probably we wouldn't be able to enforce as a requirement for licensure based on this proviso language. And when the proviso was put onto the budget, there was discussion in the budget committee about should it be removed, and they ultimately decided to keep it on there. When it got reported out to the full House Appropriations Committee, there was similar discussion, and they took a vote, but they voted to keep the language onto the budget. And then the House and the Senate passed separate budget bills and then conferenced on items of difference. The Senate didn't have any similar language to this, but when they conferenced, the ultimate consensus appropriations bill left this proviso language on the budget. So it is on the agency's budget, and it was passed in the appropriations bill. Right now, the legislature is in basically a 2-week break before they come back to resolve all the remaining items before the session is over for this year. And so in the approved budget, this proviso language did stay on the bill. So I wanted to make you aware of that. I know there's been conversations the last couple of years about possible diversity training or other similar training and how that could be something the board might recommend or require. And so I think for at least the next couple of years, this language might somewhat restrict the board from considering those topics, like I said, at least for the next couple of years. But I realize that's kind of an unusual item to have on a budget. And so I wanted to go ahead and pause here and see if you had any questions on that item.
So David, I'm going to go on a limb here and say that the next time we make recommendations, we'd be less specific and just want to add CEUs, and then this might not have been addressed. Just thinking out loud.
Well, so I think one of the issues is in statute, it says that there shall be a requirement of continuing education. And specifically in the statute, it outlines that there's a current requirement of 3 hours in ethics and 6 hours in diagnosis and treatment. And then the remaining requirements are defined by the board and rules and regulations. And so since those two are outlined in the statute, if we did want to make adjustments to those, we would have to put it into a bill.
But I think our request this year was specific for 3 credits in XYZ. And if we just would have asked for 3 additional credits and didn't mention XYZ, it probably, I'm guessing, might not have come up at the budget meeting.
Well, so there's a total number of credits that you have to get every license period. And within that amount, there's certain that the board says you should get in these specific areas. And so basically, depending on the type of license and the level of license, some of the professions have as few as 30 and some have as many as 50. So for every 2 years, you have to get that amount of CE hours. And then within those total hours, then you have to get certain specific categories.
Okay.
David, I'm just wondering, I know this piece isn't impacting like an initial license, but do we think it's setting precedents, or should we be concerned that there's a requirement for multicultural counseling in an initial license? Like, because is this something that could eventually get to that?
And I'm not sure that I fully understand your question. Could you ask it again?
So just in an initial license, and when a counselor initially applies, they have to have a multicultural counseling course. Right? Okay. So this response is to a statement of, we want them to continue to have that training. Should we be prepared, or should we start considering that that this response would filter all the way to an original license, not just CEUs? And maybe it won't, because we won't be asking, but that might be something for us to be aware of. I mean, we asked for this because because the field is moving towards this in a pretty consistent way nationwide, but I think my concern is around what this is saying to the field.
Mhm. Yeah, that's a good question. And Andrew, I don't know if you had your hand up as well. I don't know if you were going to be offering something in regards to this question, or if it's going to be a different question. But
Well, no, it's comments, and I think probably comment to both. I was actually at the hearing the day that I think we're talking about two separate issues. First is what the legislature is doing as it refers to budget and what they're going to allow or not, which our request, well, the board's request around the multicultural component didn't affect that. That, imagine that was already something that folks within those committees were already looking at, and probably, I imagine if they were on our committee or not, they didn't even know we asked for this kind of stuff. So I think these are two unrelated topics that are being addressed. I don't think that it is going to affect our general level education requirements. I mean, that's in statute anyway, what various things we're required to do and so forth in regulation. I don't see that changing, or this being changed. I think there's a certain concern within various legislatures surrounding various movements around the country, and that there is responses to what's, whether it be perception or whether actual, whatever, that people are navigating. This particular thing within the bill in 2340 was edited out actually by Representative Ruiz, made the request. And she's a Democrat from here in the area. She actually sponsored 2288. But I think the issue surrounding this, and I didn't ask her specifically why, but I think there's some concern that that languaging being in the bill may have held the bill up. That's not coming from her, so I'm not quoting her. I did not ask her about it, so please don't associate what I'm saying with Representative Ruiz. But that's kind of what I gathered, was that there was some concern, maybe somewhere along the lines, that it was felt that if that language was in the bill, that it would hold the bill up, it wouldn't get through. Now, I don't know that for a fact, but this is information that I would suspect that some people would support, but I still know they felt there's enough support for that at that time. So when you look at it, it was interesting to kind of hear the process. I don't know that saying that we would have just request additional CEs would do that, because in order to enforce it, it has to be in language somewhere saying that this is what we're requiring. So I don't know that we could have done that, but Bill, I don't think that, Jim, sorry, not Jim, not Bill, Jim, I don't believe that us requesting those CEs as part of the 2340 bill actually had anything to do with what the appropriations committees and folks were doing either. So I think there are separate things happening here. And I think eventually you'll probably see where this kind of gets through, as you see, normally the more support there is through the country where there's examples of people putting these kinds of practices in place, and people have an opportunity to explore and examine those, there typically can be more support for that. But I don't see it going backwards, affecting our LPC requirements for education. But it may take a little while for Kansas and other states to get on board with putting that in there.
So let me make sure I'm understanding. You don't think that it's because it was a multicultural requirement is why they restricted it?
Oh, no, I think the reason it was removed from 2340 was because of what it was asking for, more likely.
So my thought around that though is it's not anything different than what we require in initial training. It's something we expect to continue, not something that's brand new, right? I mean, that's the expectation. So if it's being targeted after someone's licensed, should we be concerned it would be targeted prior to someone being licensed? And it seems odd to me if it's in regulation that the response would be, no, we no longer want them to be required to be trained in that, even though it was a requirement to be trained in it to be licensed in the beginning.
Yeah, I don't know all the reasons. I know when you're at that level, there's lots of different ideas about in terms of what does it mean, how is it being defined, what are we actually requesting. So because it was multicultural, I don't know if it's issue with it being multicultural, because the person that asked for it to be removed, I don't think has a problem with that. So for me, I think there's a range of probably things related to the languaging that the folks want to try to understand. But I don't know. I'm just speculating to a certain extent. I just happened to be there when it was asked, and I was surprised when it was asked to be removed. But I don't know that we had gotten any other details surrounding that. But I know there were lots of things going on at that time surrounding various things that, like I was surprised we didn't request an amendment then to add our diagnosis hours back in versus leaving it at 3, so like there's all kinds of things happening, but without talking to the legislators, you just don't know.
Yeah, I do know in the budget hearings, they did ask some questions about the bill, because the budget hearings happened first before the bill hearings. And so even though those are two different things, I know people were aware of some of the items, and in the bill that the BSRB had brought forward the year before, there was there would have been a specific requirement in DEI continuing education for the licensed psychology profession. And that ultimately was amended out of the bill by the Senate Public Health and Welfare Committee. So, so I know that they were maybe looking for those kind of things, or very aware that we had, other things that were in motion at the same time. So, but I think at least in terms of ongoing conversations on this topic, I think the effect of that proviso is probably going to limit those at least probably for the next couple of years. But I did want to kind of shift and talk a little bit about the bill that the board brought forward. Last year, the legislature really made a statement of saying that they would really like health agencies to come forward and partner with the legislature to bring forward some ideas to address things like workforce concerns and some other concerns. And so all of you worked really hard in the advisory committee. The board worked really hard. My staff, I can attest, worked really hard as well. And ultimately, the recommendations of the board were put into a bill that was introduced this year. There was a House Bill 2340 and also a bill with identical language in the Senate, which was 176. Senate Bill 176 didn't have a hearing. It was there to allow the Senate to work on it simultaneously, but the consensus was to go with the House bill first, and then to consider that on the Senate side after the House had worked it. And so the BSRB bill essentially was House Bill 2340. And just to give you kind of some idea of some of the items that the board included in that bill. So one of the items the board had recommended changing is that in most of the statutes for the professions on reciprocity, the board had recommended decreasing the years of practice for reciprocity down from 48 of the last 54 months down to 12 months. Additionally, the board had requested language to help individuals who are currently licensed be able to maintain their licensure by adding some new language, which said for individuals who have had an extreme circumstance that kept them from finishing their CE hours, normally they would be unable to renew their license. They would have to let their license expire since they didn't have those hours completed. This new language would allow them to request additional time to complete those hours. And then if they were approved, then they could have extra time and be able to renew their license, finish those hours, and then continue forward as a practitioner. So that was also a workforce item. Additionally, there was some language added in the bill that would allow individuals who have been previously licensed by the BSRB, but whose licenses have expired and they have been out of the workforce for at least a year. If those individuals wanted to come back and reinstate their license, it would decrease the cost of doing that in half. And so it would make it easier for them to come back. And for those individuals who want to reactivate their licenses now, they have to have all of the continuing education hours from the past license period. And so one of the ways the board wanted to motivate or help individuals come back and practice again is development of a new type of 6-month temporary reinstatement license, which would allow individuals to work under this new type of a temporary license up to 6 months while they are finishing their hours they need to permanently reinstate their license. And so this would be a way for them to come back more quickly, be able to accrue those hours while working. And then once they had a sufficient hours, then they could have their permanent license restored. Additionally, we had heard that some individuals were having difficulty passing the licensing examination, and the temporary licenses that we have right now, under which you would get if you had met the educational qualifications and everything else except for passing the licensing examination. And those temporary licenses right now for some of the professions last for 1 year, for others they last 2 years. And so as a way to help with the issue of individuals struggling to pass that licensing examination, the board recommended increasing the time of temporary licenses so they would all be 2 years. And so hopefully if individuals pass the test the first time they take it, it wouldn't even be necessary and they can get a permanent license. But for those that need extra time or something unexpected comes up, it would allow them to work longer while taking that licensing examination. And it would also provide more security and stability for employers who hire some of those individuals with a temporary license. So that's in there as well. Additionally, for the social work profession, we encountered an issue the last couple of years where we have new programs that are starting, and some of these are online programs. And these are programs that are brand new, but they're seeking accreditation. And for the social work profession, that accreditation process can be lengthy. It can take 3 to 3.5 years to complete. But social work has established something called candidacy. And once you're officially approved to enter candidacy, you're meeting benchmarks along the path to becoming fully accredited. And so the issue, though, is that for these programs, if they're going through that process, you're going to have some students go through the program before it becomes fully accredited, but it is in candidacy. And how should the board treat those individuals who graduate from programs that are not accredited, but they're in this candidacy phase? And right now there's no language and statute for how to address that issue. You can look under the current regulations to see if you can meet the substantially equivalent requirement, but there's issues with that for some of the online schools, given some of the language about being physically present for some of the coursework. So as a way to address this issue, the board studied what other states are doing. There's a model that's used by Minnesota that allows individuals who graduate from programs that are in candidacy to get a temporary license and be able to practice under this temporary candidacy license. And then once their program becomes fully accredited, then they could get a permanent license under the board. Now, if their program does not reach accreditation, then they wouldn't be able to practice any longer unless they met those other substantially equivalent requirements. But this would be a way to address that short period of time while individuals graduate from programs that are not accredited yet. And so that's in the bill. Similarly, there was another bill that was introduced this year, House Bill 2375, which includes this same language on the candidacy license with some additional language that it is definitely for programs that are online programs. And so the language is slightly different, but if you saw that bill, it includes basically our base language on that topic with some additional language specifically addressing certain programs. Another item that's included in the BSRB bill is to attempt to address workforce issues by creating a student temporary addiction counseling license. And this would be for individuals who are seeking to become addiction counselors, but they still need to do some of the coursework required. And so they would have to have an agreement between their employer and also with the school itself that shows that they are on the pathway to completing those hours and that the employer intends to hire them upon completion of their program. But this would be a way that individuals could start working under the supervision while they are working to become addiction counselors. And then there were some cleanup items in the bill as well. One of the items for the licensed psychology profession changes their licensing standard to be basically that the individuals would merit the public trust instead of having good moral character. The other professions require meriting the public trust, and it's a more widely accepted standard nationwide. And also there would be some language for the behavior analyst profession. When that profession was added, the statutes were worded differently than the rest of the BSRB statutes. And so the disciplinary remedies basically say if someone violates the unprofessional conduct regulations, we can suspend the license or revoke the license, but it's missing the same language we have right now for the other professions. And that language allows us to do a small fine or a public censure or something that would be more appropriate given a small violation. And so the language here is more or less cleanup to match what the other professions allow in some terms of those disciplinary remedies. And then there was also some additional language that was added to statute as basically statutory cleanup. We looked at some of our definition sections and reworded those so they would be in alphabetical order. We found certain sections where it was difficult to understand. And so we sort of outlined a little bit cleaner the process by which individuals can request reinstatement of a license. Just a lot of cleanup things where if individuals were trying to understand the processes, we would connect those dots a little easier than having to track from one statute to another. And so all these items that I mentioned are still in the bill, and I'll give you a little bit of update about the bill itself and where we're at right now with that. So there were a few other items that were in the original bill. The bill was worked by the House Health and Human Services Committee. And when that committee worked the bill, they removed 3 items and they added 3 items. The 3 items they removed, one is what we had talked about for the new board requirement of continuing education and cultural diversity. The board had originally recommended a new requirement of 3 hours in that area. And the House Health and Human Services Committee removed that as one of the items in the bill. Additionally, there was a recommendation from the Social Work Advisory Committee to require board approval of supervisors for the social work profession. And that item was also taken out of the bill when it was worked by that committee. And the last item would have added a 13th board member to the board for the behavior analyst profession. That advisory committee had requested a new board member be appointed or put in statute. That profession was added under the BSRB back in 2014 and has grown over the years, but there's currently not a board member defined in statute to represent that profession on the board or to be able to speak to the unique aspects of that profession from a public protection standpoint. So the board had recommended language to do that, but the committee removed that, so that is not in the bill anymore. Some of the 3 items that the committee added on top of those adjustments, well, I should mention too, Andrew mentioned this as well. One of the requirements that's currently in statute is for individuals that are able to diagnose and treat. They would have a requirement to get 3 hours in ethics and then 6 hours in diagnosis and treatment. And one item that the House committee did is they lowered that from 6 to 3, which essentially in the bill the board put forward, it would reduce that from 6 to 3 and require the new 3 hours of continuing education and diversity training. And essentially the board or the committee removed the 3 hours in diversity training, but basically kept the decrease of 6 to 3 in diagnosis and treatment. And so they went ahead and left that at going from 6 to 3. I believe that's beginning January 1st of 2025. So that's the current language in that bill. Some of the other items that they added, one would be a change in the BSRB operating process. It would require the agency within 15 days of an application to have reviewed the application, determined if we have an incomplete application or if it's complete. And then if it is incomplete, to send something to the person to say what's remaining for it to be complete. And then it would require us to make a decision on licensure within 30 days of having a complete application. And one of the issues there is that right now we allow between 30 to 45 days after we have a complete application. So this new standard of a 15-day turnaround to be put into law is something we're not able to do based on our current level of staffing. And so we will work with that if that is something that ultimately would go into law, but right now we don't have the manpower to meet the requirements in law to do that. So also the requirement as far as a 30-day deadline, once we have a complete application, the issue with that is that's not always in the applicant's best interest. For example, if someone would apply for licensure right now, and let's say they came from one of those schools that is in candidacy for accreditation, if they don't meet the alternate requirements and regulation, we wouldn't be able to license them. But what we could say is that, you know, if we made a decision right now, you wouldn't be able to get licensed, but we're able to hold your application. And then if this bill becomes law, we would be able to evaluate you under that process. And so it would be to their benefit if we are able to hold that until that bill becomes law. But if this new language went into effect that we would have to give a decision within 30 days, we would have no choice but to deny the license application of that person. And then their only thing they could do after that is they could reapply in the future by paying another fee and going through part of this process all over again. So we had asked for some adjustments to that part of the bill, and I'll go through that a little bit more too. But some of the other items that were added by the committee, one would be for the social work profession. It would be significantly striking some of the current requirements for individuals wanting to become a clinical social worker. Right now, there's 15 credit hours they need to receive to become a clinical social worker. It outlines the specific categories they need to get those hours in to demonstrate that they have education, being able to diagnose and treat. This new change would strike almost all of those out of the statute. So it would only leave 3 hours of the 15. And then right now, the language says they would have to have a practicum, and then it talks about the 3 hours of postgraduate experience. And within that 3,000 hours, they have to have 1,500 hours diagnosing and treating. Well, the change the House committee made was to add language that the 1,500 hours that are currently required in diagnosis and treatment, they could be including but not limited to diagnosis and treatment and some other categories. And so from a licensing perspective, you know, trying to enforce that as a provision, if there is some diagnosis and treatment included in that 1,500 hours, we think that would be sufficient, because without being able to clarify that otherwise, that is included. And then other hours are other categories. So essentially what it would do, it would remove that or decrease that standard from 1,500 hours showing that you have competency diagnosing and treating down to 1 hour potentially. And so that is very concerning. And then the last item is one of the advocates for the bill had requested some new language to create something called a community-based license. And this community-based license appears to function very similar to a current temporary license. It would be for individuals who have met the education requirements for licensure, but have not passed the licensing examination. And they would be able to hold this community-based license for 24 months, which would be the new standard of a temporary license in the bill. And in the original version of this language for these community-based licenses, they would be for individuals who are within the employment of a community mental health center, and then they would have to be supervised by someone at a clinical level. But one of the items of concern for these new licenses is that if somebody met those qualifications, even though they had not passed the licensing examination, they did not have a permanent license, they would be able to use the title and the initials that someone currently uses right now as a permanent licensee. And this would be for the professions of licensed psychology, professional counseling, marriage and family therapy, and for the bachelor's and master's level of social work license. So for example, for your profession, if someone, let's say, worked at a CMHC and was under clinical supervision, and they were eligible for a temporary license under the board. So they hadn't passed the licensing examination, but they had met the other requirements. Currently, right now, if they had a temporary license, if they were to do certain services, they would have to represent themselves as a professional counselor with a temporary license. or they would have to use the initials with a T to designate that they are a temporary license holder, not a permanent license holder. Under this new language in the bill, they would be able to call themselves a licensed professional counselor, and they would be able to use the initials LPC without any kind of qualification. And when we found this out, we ran it by legal counsel, and they had serious concerns because we had heard behind the scenes that one of the reasons they wanted to have these licenses developed was because of some difficulty that they were getting with reimbursements for certain services. And while we're certainly empathetic to that, from a public protection standpoint, it appears to be misleading that you're going to have individuals who don't have a permanent license, that the people that are receiving services from them would not be able to know if they did have a permanent license or a temporary license. And it also calls into question anyone who currently has an LPC, or for psychology and LP, or the other types of licenses, because not only would those individuals be able to use the titles without having earned a permanent license, those individuals who currently have a permanent license, I think it could lead people to question, well, do you really have a permanent license? And from a public protection standpoint, we feel like there's too much area in here for misunderstanding. And so we expressed these concerns to the Senate when they worked the bill. I went ahead and met with every member of the Senate committee, either before the hearing or right after the hearing, before they were able to make amendments and work the bill. And some of those individuals I met with both. In my testimony, I included actual language and wording of what the amendments would be. And when the Senate committee held its hearing, I was given a grand total of 2 minutes to speak to the bill. So I tried to speak in favor of all the positive things for about a minute, and then I spoke about the board's concerns with the second minute. But given the length of time speakers were able to talk, I really went ahead and tried to meet with members outside of the committee to express the concerns. And so when the Senate committee worked the bill, they did not bring forward any of these amendments, unfortunately. And so they did pass the bill out of committee with one amendment, which was an unusual amendment. That amendment that came from that process basically said, if you had a student temporary addiction counseling license, you could not later have a community-based license, which was not something that we had requested, didn't address any of the concerns of the board. I did not know about it until that day that we were sitting in the committee room. But they asked me in committee if this addressed the concerns of the board, and we don't get the opportunity to talk when they're working the bill. But someone looked at me in the back of the room, and I shook my head that no, this is not something from the board. It doesn't address the concerns. And they verbalized that. There was a member of the committee who made a motion to table the bill because he understood the issues and the concerns. And he basically said we should table this bill to allow the individuals to work through this more. But the committee was not in favor of tabling the bill. And ultimately, they adopted that one unusual amendment and then passed it out of committee. And then after that, it was eligible to work on the Senate floor. It was not worked on the Senate floor. So ultimately, that bill would have essentially died most years. However, based on a technical rule, if a bill has passed one chamber, it is eligible for the contents to be included with other bills when those bills go to conference committee. And so right before they broke for that 2-week break I talked about, they took the contents of amended House Bill 2340 and put it with a couple other bills in Senate Bill 131. And it was put into that conference committee report. And some of those meetings were taking place right before they left, very late into the night, some as late as 4:30 in the morning. And so it was made ready and available for passage, but they adjourned for their 2-week break without running it across the floor. So that's what's currently included in Senate Bill 131. When they come back, it is eligible to be worked. But at this point, I'm not sure if it will be passed or if it won't be passed, but just kind of wanted to walk through those steps. It's been a long process. I've spent a lot of time at the Capitol, been a lot of communications back and forth. So I just wanted to pause now and see if you have any questions on any of those items.
I'm trying to think, I've been thinking about how to phrase this. So I was actually, Dave and I were at that hearing in the Senate too, for a different bill. And I was actually very surprised when some of the things took place. And I said, when did this happen? And because it had happened outside of the hearings and when the bills were being worked and weren't there, it was a surprise to me. The first thing that was concerning to me was the use of the title. And there's actually a part of me that was hoping that folks would hear that and see the problem. When I saw that it didn't get worked, I was disappointed for the BSRB, but also there was a certain part of me that was pleased to see that we wouldn't have this confusion that would be brought forth through the misrepresentation, I think, of a person's actual qualifications through legal means. These are folks that haven't even passed their national exams to demonstrate competence to be able to do the work that they're doing. And to have that privilege of that license. So that was certainly concerning. And I know that you were doing some work there to try to help bring awareness to that. So I certainly have concerns about that, trying to figure out how we even distinguish between ourselves anymore in terms of who is qualified and who's not. And one of the questions I have is around how we all get education to these folks. Even with HB 2288 on the Senate floor, there were people speaking stuff that was not accurate about the bill, that clearly hadn't taken time. And even one of the individuals was a committee member. I was given 30 seconds to testify that day, that we had 3 of us there, and I got 30 seconds total to speak to the Senate committee. And so that was a very, very brief conversation. So there was that part of about how do we help inform these legislators about the actual process? Because something I've learned is that they aren't incredibly familiar with a lot of this stuff. And I know that you spent a lot of time there, so I know you were doing that. But I think sometimes when multiple people are aware and trying to bring information to these individuals, I think they want to try to do the best thing that they can, as I've worked with them. So there's that part. And then the other part of it was about the social work end. When we talk about the standardization of many of our regulations and statutes, what I see that keeps happening is that social work continues to remove things that the rest of us are already doing or have asked to do. And what was concerning to me was what committees are being provided in terms of information, much of which maybe isn't accurate or is halfway accurate. And then the decisions being made, there's not an opportunity for that to be spoken into by individuals who would know. And so then the committees are making decisions based off of testimony that they're receiving that appears to be what they understand to be what's actually happening. And so now we're creating, like for social work, they only have to have 3 hours of diagnosis and treatment when there's already concerns about whether or not social workers at the master's level should engage in that practice to begin with. And now we're making it even more difficult to know whether or not those individuals, I know for me as a person referring out, I very rarely will refer to a master level social worker because I just don't know that I can trust the level of competence they have based on social workers I know and what their professors have told them when they're in school, which is this isn't preparing you to go out and do private practice. Like if you want that, you do extra training to get ready for this kind of thing. And I heard that many times from social work friends that were getting their training at Kansas universities for social work. So I guess the questions I have is at what point is standardization and uniformity expected? And at what point is it just, it seems like there's only certain folks that within legislation are held to that. And how do we, I guess the education keeps coming back to me. How do we help people understand what it is that we do and don't do, and the importance of maintaining the integrity of the existing system, and trying to hold all of our professions within our BSRB accountable to some of these basic level ideas to ensure public protection, competence, and so forth. How do we help do that so it's not just one person or a couple of people that are speaking to these folks?
Yeah, that's a very good question. And I think one thing that I have taken away from the process this year is, I was optimistic that if I could find time to talk for 15 to 20 minutes with each member of the committee, I could sort of walk through these different items and make sure that they understood the issues involved. And so I know that by having had those meetings, they all had the opportunity to ask questions and to be educated on these topics. But I think it is really challenging, especially because even though we brought forward this bill that was 65 pages long, and we oversee the licensing of 15,000 people, the amount of time that I was receiving in committee was the exact same as anybody else who wanted to come up and talk on any subject related to the bill. And so I think some of the advocates who have an interest in removing things either from statutes or from the bill, they can line up a few people and then bring them up, and it may give the legislature sort of a impression that, oh, well, there's a groundswell of people that are all upset about this, or that definitely want this change, when really it appears to me in some cases it's a handful of people, but they're very vocal. And so one thing that I think is very helpful is, at least I hope it's helpful, is to bring forward the truth when it comes to these matters. And I think one thing that I have heard that is particularly troubling in some of this conversation is, I know that there are issues related to workforce, and I know that there are people want to be helpful, but I think the perspective that some people think is, well, anything we can do will help. But I think you have to do things the right way. I think, we have to make sure that we use good processes, we have good conversations. An example of this is the multi-state compact for professional counseling. We had the opportunity to learn information, to ask questions. These things were worked through. But some of these items that were tacked on to the bill that have, harmful consequences, these things weren't worked through. And one thing that I did after those amendments were made is I reached out to the individuals that I believe were advocates for those changes to see if there could be any further discussions for compromise language, or to see if there's anything that we could do to kind of resolve these without endangering the public protection mission of the board. And I thought some of those conversations were productive, and I thought that was going to mean that there was going to be some reception to changes. But then when the time came for those amendments to be made, they weren't. But I did want to share one thing in particular with all of you. I do hear this from time to time in the legislative committee meetings that, some individuals will come in front of the committees and they will say, we don't have enough practitioners in the state of Kansas, because some people will say there's difficulty in licensing people from the board. This is what you can see on your screen now. I know it's a lot of numbers, but this is the history of permanent licenses under the BSRB, going back from July of 2015 to the last report I provided to the board on this. And this shows that back in July of 2015, there were about 12,152 licensees under the board. And as of recently now, that number is almost to 15,000. And so over just about 7 years, the number of licensees under the board has grown significantly. And then the second page that I usually provide to the board basically takes all those professions and rolls them together by level of licensure. So you can see everyone together by profession. And for professional counselors, going back to July of 15 to current, the number has almost doubled from 1,148 to 2,118. And so some people will come in front of these committees and they say things like, we're losing everyone because they're not staying in Kansas, they're going to other states. On a person by person level, I can't say where everyone goes after they graduate, but I can tell you that in terms of what I can see here in the numbers, I can see that our number of licensees are growing, and the actions the board is taking to address things like workforce, doing it in a thoughtful, measured way, these things are working. We're getting more licensees out into the field. Now, this doesn't mean that we don't need more practitioners. I think, especially with the pandemic recently, what I think has happened is there has been a growth in need for services. And so I think looking at things like the compact, looking at other ways that we can do licenses productively, I think those things are really good. But I think the idea that maybe, we're not licensing people, or people aren't getting through, or standards are overly difficult, the numbers don't bear that out, that we're not licensing people. I think the idea, though, is that we have to do it in the right way, because I get that certain other individuals, they may have different priorities, where growing the profession is the most important thing. But for us, it's making sure that we remember the public first and foremost, that the individuals who are going to be receiving care, those are the people we have in mind, and to make sure that we have appropriate standards. But I think we can do both. I think we can have these conversations, we can bring forward good bills, we can do good work in the regulations. But I think in the future, if we have situations come up like what happened this year, I will probably put more of a call out to people to ask more people to come and present testimony at committees, because I think the voices that are being heard, unfortunately, may be the basis of some of these changes. When I think, I'll try to be a little bit more, vocal in terms of the need for people to come to committees and really talk in favor of the changes the board is looking at, and also maybe to dissuade people from making changes that haven't been worked through.
That sounds like a great plan. And I love the idea of you bringing the data that you just shared into the light, because there's the proof right there that, the sky is not falling. Yes, we do have more demand, but the sky is not falling in the state of Kansas. There's good work being done to get people licensed, without a doubt. I like the idea of you having, asking us and reaching out for us to speak and advocate. We could all operate at the level that Andrew Secor does. I think there'd be a lot of good things to come from that. You're everywhere. I think you're cloned, actually. You seem to be everywhere. Very inspiring. But so thank you, David, and thank you for all your hard work. I have said out loud many times how lucky we are to have you as our executive director. Smart, hardworking. Can't hurt that you're an attorney. So thank you for all the hard work that you're doing.
Well, thank you, Laura. I appreciate that. I did want to let you know, like I mentioned, that bill is currently, the BSRB contents of the bill are currently in Senate Bill 131. We don't know at this time if that bill will pass. If it does pass, we'll need to make some changes very quickly. One thing that I have done, when the legislature comes back, they have something called an omnibus memo, which is something that basically they can look at as a list of items that need to be resolved before they leave. With the BSRB items not being passed into law, we're kind of in a little bit of limbo, but I have made them aware that if they do come back, I've requested expenditure authority for us to bring on 2 new licensing specialists, because I think that will be the first attempt to make sure that we're meeting those timeframes. Now, there are certain logistical issues that we'll have to get really creative on where to put those 2 people, because we simply don't have space in the office for them, but that's something that I can work with the board on in terms of figuring that out. But I want to be compliant with the law. That's really the focus here, even though it does put us in a very difficult position. And so that's kind of the steps that I have taken. And when the bill was put into conference committee, I did want to mention one more thing that I forgot to mention earlier. They further amended the bill that basically clarified that for those new community-based licenses, you wouldn't be able to get a temporary license and then later get a community-based license. So it essentially would be one or the other if you qualified for the community-based license. And they also expanded the group of providers that would be able to utilize those community-based licensees to also include individuals under the scope of employment at federally qualified health centers, FQHCs, psychiatric residential treatment facilities, PRTFs, and then private facilities as defined in KSA 59-29B46. And that appears to be the drug and alcohol type treatment facilities. And so it is just a handful of providers, but it appears that if the language as it currently stands will be passed in that bill, then these new community-based licenses would be available just for that subset of providers. And so I want to make you aware of that. We'll continue to track that. We'll put out information. If there is a bill that is passed into law, we'll send out something to all licensees. But given how unusual things were this year, kind of wanted to spend some extra time walking through those steps. We cannot control the legislature. We can put a spotlight on things, we can have good conversations, and we can try to make effective changes. But at a certain point, we're limited in what we're able to do in that realm. But I do want to thank you all for your work, and also thank the board for their work too. But I think this is going to have to be something that we continue to work at in the future in terms of trying to make effective changes, while also making sure there's not significant changes that would hurt the members of the public or the professions. And so with that, I'll go ahead and end my report. There were a couple of items that I forwarded to you in your material at the last meeting. We talked about behavioral health advanced directives. And so I'll let you take a look at that. Maybe we can talk more about that at the next meeting. We also had talked about the unprofessional conduct regulations, and Andrew had forwarded some information on telehealth standards from a few different documents. And so I wanted to give that to you too, just for your review. And so we could have further conversation at another time, but I want to make sure you had a copy of those so you could review those as well.
Thank you so much, David, for all your hard work. Okay, so we're ready to move on to the next item. Do you have anything else you want to add, David?
Nope, I think that's good.
Okay, so old business, an update from the American Association of State Counseling Boards, the conference. Well, I went, and so I'll give you the update. It was certainly hard to say yes to going to New Orleans in the middle of February. So I said yes. That's not the real reason I said yes, but it certainly didn't hurt. We met for 3 days. It was a lovely conference. It was great to meet so many of the folks who, are obviously involved on, things going on in their own states. Wyoming was, during the conference, Wyoming was voting on the compact. And so Greg Pearls kept jumping up and going and, finding out what was going on. Did I say his name right now? Greg Searles. And it passed in Wyoming. So that was really fun to, be a part of live for him. Some of the breakouts and conference discussions, supervision scaffolding. We talked a lot about crucial elements for clinical supervision so that supervisees and supervisors understand how to walk through that process together. One of the things that we spent a lot of time on was the dual relationships and how those sometimes were immediately going to get in the way of the boundaries that would allow supervisees and supervisors to stay focused on topics at hand. We talked about KCREP standards and ACA standards for supervision and how important it is to reiterate that and to have, increased training for the role of supervision so that people really understand, a certain number of tasks that should be addressed on an ongoing basis for supervisees. Let me see. Let me look at my notes. Another breakout that that we attended that I thought was very helpful. Continuing to build relationships with, pre-licensed counselors and faculty and education environments. Of course, that's important. The president of KCREP, of course, spoke about that. What else? Let me scroll through more of my notes. Of course, the compact was a big discussion, how that's going. The meetings are going to start happening. Compact meetings are ramping up. There are 2 a month, and there will probably be 3 a month as the compact gets ready to launch. Let's see. They're talking about a database for the compact where people can communicate specifically about the compact in a professional, private, HIPAA-related portal so that we can really speak freely about the things that are, going to be happening as the compact is developed. Let's see. I think that's really about it. I mean, many great discussions, many great questions. I could go on, but we have a lot of things to cover. Does anybody have any questions about what we did at the conference? Okay, well, that's it.
Hey, Laura, do we know how many states have already signed onto the compact that the compact has passed in? Do we know?
I meant to look this morning, but I was having all that, power outages. I think, aren't we at 22?
It's
Oh,
about
maybe Andrew now.
Yeah, I would say it was 21 when Kansas signed on, and I want to say I've heard that another state has also joined, since I don't know which state that was. But I think that there's at least 21 as of last Tuesday, and there could be 22. Yeah.
22,
and we have 17 waiting.
Yeah, they were
Cool.
at the conference. They said they were confident that we'd have 35, that by the time the compact was going into effect, 35, which is a great number.
Wow, that's great.
Yeah,
Thank you.
thank you. So that's all I have. If anybody has any questions, let me know. But it was great. It was a great conference. Great to meet everybody and see everybody.
Or I want to thank you for attending that because I do try to attend as many of the National Association meetings as possible. This one, with it falling right in February, right in the midst of all the legislative activity, it was one I was not able to attend, but I really am glad that you were able to go and represent Kansas and appreciate you taking an interest in all these topics as well.
Oh.
So.
Fascinating. And of course, I love it. And yes, you were a little busy, weren't you? Goodness. Okay, new business. We'll move on to that. Discussion of reciprocity requirements. So Dave
Yes.
wants to take that.
Yeah, so we've received a couple of questions or comments from individuals concerning the requirements for reciprocity. And so just kind of as a background for this, so for most of the professions under the BSRB, there's a general statute that involves the requirements for reciprocity. And so for the professional counseling profession, this would be KSA 65-5807. And so I'll go ahead and share my screen with that statute. But basically, the requirements for reciprocity would require someone to have either come from a jurisdiction with substantially equivalent licensure requirements. We're talking about the LPC level of license, or that they would need to have met certain standards which were set by the board in statutes, and they're also in the regulations as well. If they were not from a jurisdiction that had substantially equivalent license requirements, they currently would have to have practiced in that jurisdiction for 48 of the last 54 months, absence of disciplinary remedies, and then at least a master's degree in counseling or related field from a regionally accredited university or college. But then further, for individuals who are seeking the clinical level, who are coming across through reciprocity, in addition to having met the requirements for the first part, there's 3 different items that they would have to fulfill 2 of the 3 to either come through reciprocity. And so that's here in section B. They would either need to have graduate coursework as established by rules and regulations of the board or pass the national clinical examination approved by the board. Number 2, they could have 3 years of clinical practice with demonstrated experience in diagnosing and treating mental disorders, or 3, an attestation from a professional licensed to diagnose and treat mental disorders in independent practice or licensed to practice medicine and surgery, stating that the applicant is competent to diagnose and treat mental disorders. And so I think one of the questions that has come up is, so I'll show something that we sent out in the materials, and that is, so the requirements for a permanent license are not uniform between jurisdictions. And in fact, some jurisdictions don't have a permanent level of license that is below the clinical level. And so in some jurisdictions, they would have something that they would call more of a provisional license. And so you're able to get a provisional license that you might be able to renew for a certain length of time. But then at a certain point, you will need to have the clinical license. And so one of the things that I included in the materials for this meeting is a map which shows on a state-by-state level which jurisdictions require, I'll go ahead and share my screen here, which jurisdictions require the NCE and which jurisdictions require the clinical level exam, the NCMHCE, which require one or the other, or which require both. And so for Kansas, we require that for the LPC, someone would have passed the NCE, and then for the clinical level license, we require that they would have passed the NCMHC. And so you should be able to see my screen. If not, there might be just a little bit of a delay here. But as you can kind of see from this map here, there are some states that are surrounding Kansas that only require, try that again. Some of the states that surround Kansas only require passage of the NCE exam. And so through reciprocity, some of the individuals who might apply, their level of clinical licensure in their jurisdiction may not require passage of the NCMHC, NCMHCE, but they might be able to meet the requirements of that first lower level And then, as I mentioned, you have to get 2 of the 3 options to apply for reciprocity. One of those is the attestation about being able to competency, diagnose, and treat. And then the other is either passage of the examination or certain coursework. And so let's say that there's one of the states that only requires passage of the NCE. If someone were to be licensed in one of those states, then they would have passed the NCE. But then if they can demonstrate completion of the appropriate coursework that we have in regulation, they would not need to demonstrate passage of that clinical level exam to qualify under the existing reciprocity statutes. And I hope this is helpful to kind of walk through these steps. It's a little bit complicated, but basically, it creates a standard where there might be individuals coming in through reciprocity that would not have to pass the same test that we require here in the state of Kansas. And I'll go ahead and kind of stop talking here and yield to individuals who have other comments on this, but I know I have heard a couple of comments about this, and I think other individuals here in the advisory committee have as well. So I'd be curious to hear your thoughts on this. And Andrew, I see your hand is raised. We may not be able to see everyone, so if you do have a comment, just go ahead and share your thoughts after Andrew talks.
The only reason I'm asking is I thank you, Laura and David, for allowing this to be on the agenda. I appreciate that you guys were willing to let us have some time to talk about this. So I think David and I both kind of, at least in one instance, heard from the same person. And one of the issues, the reason this came about was because we have some folks that are supervising Missouri and Kansas LPCs towards training plans. So they're approved supervisor in Missouri and approved supervisor in Kansas. And they have LPCs who are now learning about the loophole in our system of licensure, where they're either not able to pass the NCMHC to get licensed in Kansas, or they just don't want to take it. And so what they're doing is they are getting their LPC in Missouri, and then they're just automatically, because they were educated in Kansas or in an area that Kansas already has accepted, and then they're getting a supervisor's attestation just says they're good. And so then they can get reciprocity without having to meet the same requirements that people in Kansas have to meet. And so there's been some concern about whether or not that's equitable, that Kansas licensees have to engage in the years of supervision, as well as the money and the preparation to pass another national exam, because in our standards, you have to meet LPC requirements. So since Missouri requires the NCE, I believe it's also able to accept the NCE because it's a national exam. Or so they've completed the national exam. We don't accept that, but so they have essentially, there is a loophole that they can use coming. This is only from, I'm not just accusing Missouri of nothing. The issue has been brought because we have Kansas, Missouri LPCs with the same supervisors that are seeing this play out. So I just want to make sure people know this is nothing against Missouri. So that's why I was being brought up is do we see an issue here with individuals being able to circumvent our licensure requirements? And with the compact, I know that creates a whole other set of things. Although they're not getting a license to practice, they're getting a privilege to practice in the state, which is a little bit different, but still force of licensure. But part of the issue is, should we, outside of this normal area, a person would have to have practiced 3 years at the independent level. That's all already in there in order to qualify. There's 2 attestations that a person can receive. Like David was mentioning, either you have to have the education or pass the national clinical exam, or you have an attestation from a supervisor that says that you practiced at least 3 years and there's hours and such defined, or you had an attestation that says you're competent to diagnose and treat. So basically what people are doing now is if they have the education and they have a supervisor willing to say they're competent to diagnose and treat, even if they haven't done that 3 years, they can now skip the other parts and get licensed. So the question is, are we okay with that? Maybe we are, maybe we're not, but I just figured it was something worth us talking about since the concern was raised. And I figured this would be the body to kind of talk about whether or not we see an issue there or not.
Well, I do see an issue, but I also have, so I was licensed in Missouri. I went to school in Kansas, licensed in Missouri first, practiced in Missouri, always with an intent to become licensed in Kansas. So met all of Kansas, at the time, Kansas requirements were much higher. And so that loophole was not existent then. So it clearly has gotten developed somehow. But I do think, I think the concern is that I don't know if I would say that the exam is an end all of ensuring equitableness or a skill set. I have a little more concern with the reduction of hours of practice. Like if that piece, so in Missouri, they get a PLPC, and at least at the time that I did it, everybody moved up to an LPC, and everybody did that in 2 years. So let me make sure I'm understanding the loophole. They would still do those 2 years, but not the 3 years after as an LPC. That's the loophole, or one of the loopholes.
Well, the loophole is that they still do the time that Missouri requires to be an LPC, but they aren't, because they meet the educational requirement, which is another thing I wanted to ask about, because there's a thing in the educational section which indicates something that I don't know that we actually are able to actually prove is happening. So I'll mention that in a second. But yeah, they would skip over that. They skip over the actual 3 years of independent practice because they're not independently practicing till they're an LPC in Missouri. So what happens is that what our current system says is that if they meet our educational requirements and their supervisor is willing to sign off saying they're able to diagnose and treat, then they are eligible to get reciprocity in Kansas at the clinical level without having had the 3 years requirement or the exam requirement. So that's how they get around. The other part is they say they have our education and their supervisor says they can do it.
And this is their supervisor for their PLPC.
It just says a supervisor. I don't know if it specifies that. My guess is that they would ask the supervisor that's doing their supervision for their training plan to fill that out. I have concerns about whether or not people are really being adequately prepared and trained. So what does that supervisor attestation actually mean? Who's going to say no when they are being asked for that? Yeah. So.
But I kind of have a question about the national clinical exam of why we cannot continue to just require that. I didn't find that exam to be all that difficult if you knew how to diagnose. So I would think that if you're coming from Missouri, Oklahoma, or Colorado, and you have a supervisor saying you're able to diagnose, that they should be able to take that exam and do quite well on it. It's just my own opinion. In our practice, I'm just seeing so many people come through the door who cannot diagnose. In their training, they're not getting that training. And so I just am a little concerned about disqualifying an examination that shows that you can do that. But
So I think that there is a technical answer and then there is a philosophical answer to the questions that you asked. I'll share my screen again here. One of the technical answers is that I'm sharing again the statute, which is the KSA 65-5807. And so basically under section B here, it talks about applicants for clinical licensure and that they'll have met 2 of the 3 requirements. And so in the statute, it says, number 1, either graduate coursework as established by rules and regulations of the board or passing a national clinical examination approved by the board. And so since this is in statute, the only way to be able to change that as an option would be to put something into a bill that would change the law. But philosophically, if you believe that the national clinical examination, that coursework was not sufficient, that you could request something in a bill for next year that would make that change. But based on what the statute is written, it would allow either option. Here is the regulation that I'm showing you here. And so this is basically the regulation that corresponds to that statute. And so here in section C, it basically says, like the statute does, you would need to meet two of the requirements. And so A is the part that talks about the coursework, and really A1, A2, and A3 identifies the coursework that would be the equivalent to passage of the national examination. So if you wanted to make a change, one way that you could would be to request something in the bill next year that would remove this is a possible option that would be equivalent to the test. The other that would not require something in the bill would be to look at what's currently in the regulation for equivalent coursework, and then to have a conversation or think about whether this that's currently in the regulation is sufficient for matching that requirement of the test, or whether there needs to be something different, or whether we need to have a better process of ensuring that these things really are identifiable in coursework requirements. So as a technical answer to your question, I thought I just kind of outlined that. Since it is in statute that we would need to have something, we couldn't just remove it as an option right now. But we would be able to adjust things in regulations in terms of what coursework might qualify.
And while you're looking at that, the one area that I had mentioned earlier that I was concerned about how we are able to verify is 1A3, which says coursework that addresses interdisciplinary referrals, interdisciplinary collaborations, and treatment approaches. I don't know how we verify that that actually is being accomplished, because I know depending on where you're going to school, and even depending on what track area you might be, even within KCREP, that not all areas are even receiving that kind of information. If you're a clinical mental health counseling, it's almost a guarantee you're going to get that content because you're being trained to work within multidisciplinary service settings and so forth. But outside of those areas, but if you're KCREP, again, we accept that anyway. But it's for folks coming to us that we're not familiar with, that aren't Kansas trained, that are requesting this up. That third one, I'm like, and also we require 3 hours within our training, I believe, in order to be approved for licensure in Kansas, but yet our stuff here only requires 2 graduate semester hours. But that third one there, which these are not in statutes, this was just defined in regulation. I don't know how we verify that third part. So that was one of my concerns there too. And I don't even know if this is I hadn't even really thought about this until I got raised and I started looking at it, and I thought, well, that is interesting, isn't it? Maybe it's a problem, maybe it isn't. Maybe we need to take out, I know David, was it Leslie said that the social work took out the education requirement, and so it was only that you have to either pass the exam or you have to have an attestation, or did they take out 3, which was the attestation from the supervisor? I'm trying to recall what she said when we spoke to her.
Yeah, we had a little conversation ahead of the meeting. Leslie's on vacation this week, and so she may have to be part of this conversation when she comes back. But we did talk a little bit that social work in the past, sometime before my time with the BSRB, had something similar to this, and they removed the essentially the highlighted part. So whatever that they had previously allowed as coursework in place of the exam, so that it would either be passage of the exam or the 3 years of practice, or the attestation, and you needed to get 2 of those 3 for social work. So with this, it's really 3 items, but the first item has 2 options, the coursework or passage of the exam. So it sounded like in the past, social work had a setup like this and then removed that option of the coursework. But I think for right now, for your purposes, since it is in statute, it's something that would not be able to be removed unless another bill was passed.
But we could, if anything was looked at, if there was stuff in regulation, such as the stuff that's highlighted that defines what education is, that's stuff that could be addressed through regulation change versus through the statute.
Yeah, it's a great place to focus. We have more agency about that right now.
Yeah, I'm not saying we make changes today. I'm just wondering, like, if the advisory committee were wondering about that, because when you showed us the statute, David, it didn't list out what was the regulation defines what meeting that educational requirement is, but the statute, I don't think held that.
Right.
Yeah.
It just graduate coursework as established by rules and regulations of the board. So.
Okay.
This becomes an ongoing topic, an important topic. It's something I think we should take into consideration, but it definitely is ongoing.
I'm really fascinated by the map. I'm looking at this map. I'm really fascinated by by it because I've been licensed in 3-4 states now. I started in Ohio, Kentucky, Missouri, and then Kansas. And so I'm looking at this map. I'm thinking because I can see, Ohio and Kansas are about the same thing. That's where I started from. So it was easy for me to connect Ohio and Kansas. But in Kentucky, it's so different. It was interesting to see the difference between Kentucky and Ohio. So I was counting the numbers here. It looks like those who require either the NCE or the MHC, there's more of this 20-something, 21 or 22 states there. I don't know whether that's where everyone is going to go, but it looks like the states that are more the Ohio used to be just like California and Virginia and Nevada. That's what Ohio used to be before they changed it to the 2-tier that we have now. So I don't know where the wave is leading, but let's look at the rest of the country. Where is everyone going? I don't know. It looks like where you see Missouri and the other states, it's not like 7 or 8. So it looks like something is going to have to change there because they are way in the minority. So it looks like something is going to change there. Because like Andrew was saying, I'm supervising a few students now in Missouri and Kansas, and those questions come up in supervision all the time. Okay, if I'm in Kansas and I can't pass the test, and I've already practiced for so many years, can I move over to Missouri and get licensed there? In Missouri, the difference is in the supervision. In Missouri, you cannot operate independently, but you can in Kansas under supervision. In Missouri, you're in supervision every week. In Kansas, is 1 to 15. One supervision hour to 15 hours of work. And so there's so many differences that it's so I don't know. So I see the loophole that Andrew is talking about, but I'm not sure how to remedy that if we don't have uniform everywhere. I'm looking at this map. This map tells the story, So this map tells the story. So anyway, that's my little contribution right there.
Thank you.
I did get this map from NDCC, and I think it's a really interesting map. I also said, when I was talking with them, I'd be really curious to know what levels of licensure those states offer in terms of permanent licenses, to see if, which states only have a clinical level license, or, are there other types of licenses? Because I know that there's a lot of terminology that's different, scope of practice that could be different, but knowing what's a permanent license and what's not, that would be helpful to be able to use with this map. They said that they have not put that together, but they thought it was interesting and said that they might consider working on something like that in the future. But I do think that's something that I had hoped to research between this meeting and the next meeting, because I do think that's a part of maybe some of the differences. If there are some jurisdictions that only have a clinical level license, that may affect what type of tests they might require or not require. So I'll try to do a little bit more research on my end. If some of you have access to that information, feel free to research it or bring something back at the next meeting too.
I remember Ohio used to have just the national mental health exam. That's what they used to have until 2006. That's when it was changed, because lots of people were failing it. That's what I see California. That's what I see California, Nevada, think Florida and Virginia and maybe some other state up north. That's what they still have. Ohio used to have that until 2005 when they changed it because because they had a lot of diagnosis with it, and so a lot of students were failing it. That's why they changed it. So I don't know whether they're moving. So they moved to start to have the two tests that we have right now, like we have in Kansas. So I don't know what direction the wind is blowing. I'm fascinated with the map. Just saying.
I would just say to make sure, as I'm going to wrap up my comments on this piece here, is I know that our job is not so much about whether or not things are equitable or fair. It's do the requirements that we have. Is that ensuring the people that are able to get a license here based on how things are written, are we ensuring those folks are competent to practice at the level we're saying they're competent to practice at based on what they've done? Because I know that's at the end of the day, that's what we're talking about is public protection, and are we ensuring that whatever systems we have, that those folks that are getting those licenses can do the job that we're saying they can do when we hand that electronic piece of paper. So I think that's where we should be focusing. I know sometimes it comes to us from this isn't fair kind of thing, but I think for us we can consider that. I think it's really about our systems protecting the folks that are vulnerable. So
Andrew, I want to thank you for making that. As the public member of this board, I need to look to you as the professionals to determine what you think are the best and right qualifications in order to treat the residents of Kansas. And I hope that this board, this advisory committee over the next few months, if there are recommendations that need to be made to change 1, 2, and 3 to maybe make 1, 2, 3, and 4 to require 3 or 4 instead of 2 or 3, I hope that it comes from this group to the board so that the board can at some point potentially consider and take action to make recommendations to the legislature for change next year. I am concerned that a lot of people I have read and the board has addressed and talked about information that leads to the people have trouble passing a test, so let's not make them take a test. And I'm unfortunately old and gray, and so I remember when you didn't pass a test, it just means you couldn't do something, and I guess somehow people seem to be wanting to change that. I'm not there yet. So hopefully this group considers this, continues to consider this, and if we need to make changes, that this group recommends those proposed changes to the board for consideration.
What Jim said. So please do your research and bring back ideas to our June meeting, and then we will take those on to the board if we figure out some considered solutions. Anyone else?
Sorry, let me allow Andrew. Can you clarify your question here then? So would the question be, I'm trying to understand where you're coming from. So do we say, is a 2-tier necessary, or do we switch to, I don't know, or you're talking about competence here. So are we having competence if we have people who are taking the National Mental Health exam able to diagnose? If not, should we change something? I don't know. What's your question? So that we're going to.
Yeah. So my question is, if the way that our current reciprocity regulations are written, do they actually allow us to, or those that are asking for reciprocity, does that actually demonstrate they're competent to practice at the independent level? So for instance, if a person has the right classes from their degree and they have a supervisor who's willing to sign off saying they're competent, does that actually for us suggest that somehow these folks are competent in lieu of passing the national clinical exam or the 3 years of independent practice that others would have to follow or so forth? So I guess that's the question, is are our reciprocity requirements as they're currently written actually accomplish what we hope that they would, which is to give us a way of knowing that people are actually able to practice at the clinical level in our state? I think that's the question.
Andrew, and I think that depends the state. There's some states who are more rigorous than others.
Sure.
And I know that when I was in Virginia, Virginia changed the law because people who come from Florida came out and they have a whole bunch of interesting things in their records, you know, and Virginia was not paying attention. So I think that it's not an easy question to answer, but I think that's probably one of the first pieces they're going to be looking, where the state they come from. You know, if the state they come from, you know, have some really good, rigorous, you know, regulations, then we can at least be, you know, in peace, that we know that we make the right decision.
Right. And I don't think we're looking necessarily to make things harder. I don't think that's the thing, right? I mean, we've all experienced how hard it is to get licensed anywhere else. I think the question is just, are our reciprocity requirements as they're potentially being used protecting the public? Like, are we protecting the public with the existing system we have? And if we are, then fine, we leave it as it is. But if we look at it and determine that we aren't, then we need to do something to ensure that we're not creating opportunities for folks that maybe shouldn't be practicing in our state with that level of license to be able to do so. So I think that's what we're really looking at, is not harder, but just making sure we're doing things as our regulations were designed for us to do. Does that make sense?
I think that makes perfect sense. I think the issue really is I'm hearing, and it sounds like that somebody with reciprocity would not be of equal standing of a licensed individual that went through the process in Kansas. And to me, that's the whole point of reciprocity, is that it's meant to be an equal move over. And if we can see that that isn't happening, then that's a concern with the reciprocity process.
Right, exactly.
Just a little caveat is, let's not forget that the compact is going to be sort of kind of reciprocity. So let's not forget that, because once you have compact, everybody's in the same level at this point. So let's think about that.
And I did. I mean, I've thought about that too. I came into this fully aware. I mean, I've read that compact legislation front and back many times preparing for testimony. And there is a provision for reciprocity based on a privilege to practice that is in there. And a privilege, while it has the force of license, is not a license. So the system of licensure doesn't change for any particular state. So the question becomes, for any state that wants to grant their full authority regarding a license with that name on it, you still have that thing to look at. But you're right. The topic of reciprocity or the privilege across those state lines, that is a factor that we consider. But that's an opt-in thing though, too. So people don't have to be part of that, which means we still have a responsibility to look at all those that are not part of that system, that are not opting in to the FBI background checks and all those kinds of things that being part of the compact does, and that are part of that interstate disciplinary like database that we can all check in against each other. So there's still a responsibility we have to our existing state licensure system that we have to shore up, because only people that are part of that compact that opt in will be reviewed and such through those mechanisms. So I agree with you, Acha, and I think there's also reasons for us to consider this in addition to that.
So that leaves this as a very important and ongoing discussion. So I know David Fye will go out and do his research. I will do more research. And I hope that all of you do too. Let's be sure and pick this back up in our June meeting with hopefully some good solutions for how to make this work. Anyone else? Okay, thank you for bringing this to us, Andrew, and thank you for the discussion. Let's go on to B, a new business discussion on change to clinical training plans.
Okay, and this will be more of a homework item, I think, for the next meeting. But basically in KAR 102-3-7A, that's the regulation that describes postgraduate supervised professional experience required to be a clinical professional counselor. In that regulation, the last item, which is item H, includes language which says all changes to the clinical supervision training plan shall be submitted by the supervisee to the board for its approval. The changes shall be submitted no more than 45 days after the date on which the changes took effect. If the supervisee fails to submit the change to the board within 45 days, no supervised hours of practice shall be accrued or credited for any practice beginning on the date the changes took effect through the date on which the changes to the plan are approved by the board. And the reason we brought this up is because there have been some questions over the years in terms of what really qualifies as a change, and what really does need to be submitted to the board for a modification to a training plan. And there have been some individuals that have not submitted a change when they should have, and then they went to seek licensure, and because they had not provided the board with an update to their training plan, then those hours didn't count after that time period pursuant to the regulation. And so they have lost a lot of hours, they've lost a lot of time, but also from the perspective of the licensing body, we want to be able to provide good information if people have questions. The reason this language is in here is really to try to help the process, because we're trying to make sure that people don't come to the end and then have wasted time on things that didn't count. And so this language is in here as a motivator to try to make sure that people provide timely updates to the board so we can review them and approve them. But there has been a question of what would really constitute an actual change that would need to be reported. And so we've worked with our staff here on a list of possible changes. And some of those could include things like a new or additional work site, a change in position at an approved work site, changes in duties or responsibilities at an approved work site, a new or additional supervisor, adding group supervision after a training plan is approved, or the supervisee is no longer accruing hours towards clinical licensure, either taking a break or just stopping. And I guess the reason I brought those up is because we are looking for input from the advisory committees in terms of modifying this regulation, because we would like to put more of a list into the regulation of easily identifiable things. That way, when individuals are submitting a training plan, we can have a very clear set of standards that basically says, if you're in this scenario, you need to submit a change to the training plan. We hope that they already understand that. And for the number of individuals affected, it's actually a pretty small group. Most people submit these changes. The problem is the small group of people that are unfortunately running into trouble with this. The consequences of not doing this correctly can be very costly, and it could also, mean that they have spent a fair amount of time they have to do over again. So think about things that would need to be put into the regulation that would be examples of changes that would be appropriate. So be thinking about that. And then also, if there's a better solution for we don't want individuals to not submit changes to the training plan, but that is a pretty steep consequence that if you don't submit them, you lose all hours after that. So if there is something else you have in mind of some way to deal with that issue, think about that and bring it back to the next meeting as well. But ultimately, we would like these to be brought back to the boards. The board can try to have uniform language between the professions in terms of what types of changes need to be reported. And then if there's a better solution, we've talked about some things here in terms of the licensing body's perspective, in terms of are there ways that we can send out reminders to people with some frequency if they have a training plan, just to make sure that they have at least maybe every 6 months or so have a little email from the board that says, have you made a change? If you have, please make sure you report that. Because right now we only hear from people generally at the beginning and then at the end, unless they have questions during that process. And so we're trying to help out. We're trying to make this clear for everybody involved. So think about this and then bring back some items for the next meeting so we can have a conversation on this topic.
Thank you. Do we have the rubric or the questionnaire available for setting up a treatment or supervision plan? Because if we do, can we get a copy of that so we can all look at it?
Yeah, like I could have that sent out.
Please. Thank you so much. Thank you for that. Okay, do we have time for regulation review? I don't think we do.
These are actually 2 more homework items. So I think I can describe what needs to happen to the next meeting. So one thing is that a bill was passed last year that basically said all agencies are on a rotating time frame where you need to be reviewing your regulations. And for the BSRB, we're required to give a big report in 2026. that for each of our regulations, we have to say, is this regulation necessary for the implementation of state law? And if it's not, we need to take steps to repeal some of that regulation. But also there have been criticisms of agencies not going through and making sure that our regulations are up to date. And so we want to be responsive to that too and make sure about these. And so there's a regulation 102-3-10 that outlines continuing education, how many hours are required, what types of things would constitute continuing education, what types of things would not. This was last updated in 2003, so it's definitely a good idea for us to review this. Think about anything that maybe is not described here that would be helpful to include in this, and then bring it back to the next meeting and we can have a conversation on it. Additionally, there's sort of a companion regulation. It's 102-3-11A that describes documentation for continuing education. And that companion regulation, it's very short, it's only half a page, but it describes the type of what would need to be provided as proof of completing that continuing education hours. And this was last updated back in 1997. And so if you think about the changes in technology and the internet over the last 26 years, there definitely needs to be some modifications and changes here. So be thinking about possible new language to put in here, things that would need to be changed or removed. Some of this is at a high level, so it probably still can be adapted. So I don't think we need to replace it all, but please review these both and then come back with suggested changes. And then these can be forwarded to the board and we can try to make these types of regulations uniform as well.
Great. Okay, we have a lot of homework. All these educators ought to take that to heart. Okay, so anybody have any questions about that work that needs to be done? Okay, our next meeting is Monday, June 5th at 10 a.m. And we need a motion to adjourn.
So moved.
Thank you, Jim. Wait, who said that first?
Michael.
Oh, Michael, thank you. And Jim seconded it. I saw this. He pieced out on that. Okay, thank you so much. All those in favor say aye.
Aye.
Aye. Aye.
Any opposed? Okay, thank you so much for all your hard work and for your time. And I will see you all, we will see you all in 2 months.
All right.
Thank you. Everybody have a great day.
Take care.
Bye.